In New Jersey, we do have a statute under what is known as Title 30. Title 30 does authorize the agency to take an involuntary removal of a child anytime that a parent previously lost their child to an involuntary termination of parental rights. Now, that doesn't mean that a child having been lost to the system would mean that a parent can never reproduce again. If a parent does decide to have children again in the future, the question is always going to be, how is the parent functioning at the time that they have a child in their care? Do they have the same ailments and conditions and concerns that they had when they previously lost their child? If they have the same concerns and they haven't addressed them, then of course the agency has the obligation to ensure that that child is safe, and that usually does mean that they will remove the child. But that doesn't mean that they do not have the obligation to inquire as to the well-being of the child. It just means that they have one statutory benefit, which is that they no longer have to take reasonable efforts to ensure that they are assisting the parent to address the concern. So whenever there is a concern about reproduction after there has been an involuntary termination of parental rights, you should consult with an attorney to understand what your rights and responsibilities are, and you should do that as soon as possible, either at the time that you know that you're pregnant or conceiving a child, or as soon thereafter before the agency gets involved and removes the child without query.